Stand clear of the closing doors, please.
Hi, my name is Amelia, and I'm going to tell you a little bit about BGSU Votes. BGSU Votes is a nonpartisan student-led initiative that focuses on increasing civic and democratic engagement among college students. The next election is May 5th, and it's a primary election. To vote in this election, people must register by April 6th, 2026. In the fall, there's an upcoming election November 3rd. To vote in this election, people must register by October 5th, 2026.
Welcome aboard, everybody, to another episode of the Democracy Exchange with the Depot. I am here for a part 2 episode with my professor, Dr. Edge, who I took a history class / ethnic studies class in the history of voter rights. And it was such a good class. I invited him here for the podcast. So last time we left our conversation talking about just getting into the Voter Rights Act and why it was important, why it was prioritized in the civil rights movement. Have we started talking about the implications of it yet?
In looking at the implications of it, the most direct outcomes were certainly both the direct influence on voter registration and then, by extension, the direct influence on who was running for and attaining public office. So in terms of voter registration, we, over the course of several decades, saw steady increases in the number of people of color registering and participating in elections at all levels of American politics. So much so that by 2008, we had actually for the first time reached a point where the percentage of black registered voters in the United States who participated in that presidential election exceeded the percentage of white registered voters that did. Now, in terms of how this translates into people in public office, we would see the growth of groups like the Congressional Black Caucus, the Congressional Hispanic Caucus, and so forth, reflecting the diversification of our politics at the highest levels of government. Over time, while they still lag behind their numbers within the general population, both Black and Latino office holders have increased many times from the 1960s through today, so that while again still lagging, we have gone from, I think, for Black elected officials about 1,600 in the mid-1970s to over 10,000 today. Now, this is, of course, nothing to sneeze at. And when we start looking at the ripple effect it has, what started with largely black officials has now had an impact on Latinos, on Asian Americans, to a lesser extent, Native Americans running for public office. So by all of those measures, and especially looking at voter participation over time, the Voting Rights Act has been a resounding success. In fact, one could say that it was the most successful civil rights act in American history in setting out what it attempted to do.
How does it benefit other ethnic and racial groups, not just African Americans?
Okay. In terms of other groups, part of what we need to look at is the additions to the Voting Rights Act over time. When it was first enacted in 1965, it was enacted for a 5-year period. It was renewed in 1970, it was renewed again in 1975, it was renewed again in 1982, and then finally 2006. So those initial renewals in the 1970s paid particular attention beyond race to the question of language. And there are important clauses in the Voting Rights Act that include that you have a right to request an interpreter, that people for whom English is not their first language should not be disenfranchised over that fact. This doesn't just have important ramifications for a number of groups within the mainland United States, but it's also a reminder that the U.S. includes Alaska, it includes Hawaii, it includes Puerto Rico as U.S. citizens. These are all people who are more likely to be affected by these language clauses than many people realize. So, looking beyond simply the question of race in and of itself, race can have other proxies, with language being a very essential one. I would point out that even going back to the original Voting Rights Act, that race, of course, was not the only protected category in there, that among others, one of the ones that gets overlooked a great deal in the original act is the military. That there was language in there making sure that military members, particularly those serving overseas, had adequate opportunities to register and to cast their ballots, even though they were not going to be present physically for an election. So that right there reminds us that when we're looking at any civil rights law, the idea of protected class never includes just race. That at the federal level, we have protected classes around race, around sex, around things like military status. And when you start adding in state laws, this can also include things like whether or not you're married, your family status. There are certain things that are not necessarily protected, like your politics, your whatever political party you ascribe to, but the protected classes go so far beyond race, and usually that seems to be the only one we focus on, and we kind of do that at our own peril.
All right, thank you. I would like to narrow in on the Voter Rights Act to specifically Section 2 because it's becoming more prominent in today's world. So for my listeners, just to review, Section 2, Part 2 of the VRA, Voter Rights Act, states no voting qualifications or prerequisites to voting or standard, practice, or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color, or in contravention of the guarantees set forth in Section 1973B. In 2013, correct? 2013, the Supreme Court heard a case about Section 2 of the Voter Rights Act, which would forever change the interpretation of it. This Supreme Court case was called Shelby County v. Holder, and the implications of the 2013 case still lives on today, and we are going to get into why there's another Supreme Court case in a second that will also have to do with Section 2. So before we get into that, will you explain a little bit about Shelby County v. Holder and what's up with the Supreme Court looking at changing the interpretation after all these years?
Okay. In Shelby County v. Holder, the county sued in 2010 initially, challenging two key sections of enforcement within the Voting Rights Act, Section 4B and Section 5. Now, you referred to Section 2. Section 2 has very broad language about any mechanisms that are being used to hinder the right to vote on the basis of race. Now, 4B and 5 essentially put that into action. With 4B, it set up certain coverage formulas, they were called. It set up these coverage formulas to say that based on the conditions at this time, these are the criteria we're using for enforcement of this next section, Section 5. And Section 5 refers to pre-clearance. Pre-clearance simply meant that areas that had a history of discriminating on the basis of race when it came to voter registration and just casting their ballot, that they would have to submit any changes in voting rights to the Justice Department for review ahead of time. That would give the Justice Department an opportunity to then intervene if they thought that this had a potentially negative impact on any group being able to participate at any point in the voting process, from registration up to the actual vote itself. This became one of the most important, if not the most important part of the enforcement of the VRA, because it meant that instead of just reacting after discrimination took place, we were preventing it up front. Shelby County argued that this was unconstitutional, in part because it only applied to certain sections of the country, and in part because they felt that, well, some of this might be outdated. Now, mind you, this had been just renewed 4 years earlier, in 2006, before they filed this lawsuit. And at the time in 2006, Congress passed this almost unanimously, and they reviewed those coverage formulas. And they came away saying that we think that these areas are largely, they should still be covered by preclearance.
Do you know which areas? Are you going to say?
It is safe to say that most of the areas we're talking about are in the American South. There is language in the VRA, and especially after the 1982 renewal of it, that did stipulate that areas under preclearance can get out of it. It's a bailout mechanism, so that if you met certain requirements, most notably that you had not engaged in any of these negative mechanisms for a 10-year period, that you were not currently facing any lawsuits regarding discrimination, and that during those 10 years, neither the Attorney General nor the district court responsible for reviewing these, that none of them had said that you were engaging in discrimination, you could apply to the courts and be cleared from these requirements. Some states that had come under preclearance after 1965, and especially with some of the changes made in the 70s, they were able to apply and get out. They showed that we had a clean record over a 10-year period, and the emergency passed. But states like Georgia, Alabama, Mississippi, Louisiana, Texas, the Carolinas, these were almost exclusively still under preclearance. Some states like Virginia remained under it, but significant parts of it, many counties, were able to prove we've not discriminated, we should not be subject to preclearance anymore. So it showed that it could be done, including for Shelby County, but that discrimination was still ongoing, that preclearance was still very much needed. In 2013, however, the Supreme Court disagrees. By a 5-4 decision came down in June of 2013, the majority on the court decided that these particular coverage formulas were out of date, that they referred to conditions as they had existed several decades earlier, and that they did not fully take into account that the map of voting rights challenges and voting rights restrictions had changed in that time. Chief Justice John Roberts, in writing about this, indicated that there were states outside of the South that were not subject to preclearance, but that had been subject to intense voting rights challenges in recent years, and that there's nothing here that would now subject them necessarily to preclearance. Now, in her dissenting opinion, Justice Ruth Bader Ginsburg took issue with the findings of the majority. First, while the majority seemed to play down the idea that there was ongoing racial discrimination in voting, and especially the concurring opinion from Justice Thomas, Ginsburg pointed out all of the evidentiary documents that had been considered in 2006 when renewing the law to begin with, that there was still ample evidence, and perhaps the best evidence being that none of these states had been able to exercise the bailout mechanism, that if they had gone a decade without doing anything discriminatory, they wouldn't be subject to preclearance anymore, and yet here we are. She also pointed out that they're confusing the success of this with somehow a change in how racism functions. She argued that we should not take down civil rights laws simply because they've been successful in addressing discrimination, that is exactly why they are there, either to prevent it from happening in the first place for fear of the law, or to give us legal weapons for addressing them. And she famously made the comparison to throwing away your umbrella because it's not raining outside right now. Now, I would argue that the first part is actually the much more important. We paid attention to the umbrella one because, let's be honest, it's a great metaphor. Having said that, she identified that there is ongoing discrimination. She said that it has been documented by the federal government, that there are plenty of examples of laws that did not pass through preclearance because the Justice Department and the courts said these would have a discriminatory impact. And yet, preclearance fell by the wayside. Now, to be clear, John Roberts in his decision struck down specifically the coverage formulas in 4B. He left open that, yes, preclearance could still exist, but you need to come up with new formulas based on current conditions, not the conditions either at the time that the Voting Rights Act was originally written or after some of the subsequent revisions. Justice Thomas, in his concurring opinion, actually argued that Section 5 should be eliminated completely, that there should be no preclearance at all. But Justice John Roberts actually left that open. What happened instead is that by eliminating the coverage formulas, now you can't apply preclearance. There's no formula to say that these are the areas of the country where this applies. What he did was toss it back to Congress and tell Congress that if they revise this and made new coverage formulas that better reflected the conditions that exist now, that Section 5 would once again be enforceable. So far, in the almost 13 years since then, Congress has not acted. There have been several attempts, most notably in recent years, the John Lewis Act that has been introduced that would provide a new standard, one that is not tied to the conditions of the 60s and 70s, but that looks at whether certain jurisdictions have been accused of and have participated in voter disenfranchisement or racism when it comes to voting in any recent decade. That they use a certain number of, if you have a certain number of offenses at the state level or a certain number of offenses at the county level, then these jurisdictions can come under preclearance. So far, there has never been a vote on this on Congress floor. Right now, it is simply stuck there, and it does not show any signs that it will be moving out of committee anytime soon.
But yet we keep hearing the Supreme Court continue to hear additional arguments to change the interpretation. What would it do if we, not to predict how the Supreme Court's going to act, but what do you think would happen if the interpretation of the Section 2 of the Supreme Court of the Voter Rights Act was to be changed?
Well, the current case before the Supreme Court, Louisiana v. Calais, does focus more particularly on that section. And in that case, Louisiana, after the 2020 census, was reviewing its legislative districts, and what it found was that the population based on the 2020 census was about 1/3 African American. However, when the legislative maps were being drawn, what they found was that they had one majority black voting district out of the 6. It was taken to court. The courts determined that this was artificially diluting black voting power in the states. They went back to the drawing board, and in 2024, they produced a new map with 2 black voting districts out of the 6, which would be equivalent to about 1/3 of the population. Now they're back in court over that map, and specifically whether it is doing too much to take race into account in drawing these legislative districts. Now, under the interpretations of the Voting Rights Act up till now, you cannot form discriminatory, gerrymandered districts just on the basis of race. You can legally do so on the basis of political party, but not on the basis of race. Now, here's where it gets tricky, because the Supreme Court has recognized that in some cases, in certain jurisdictions, that there can be considerable overlap between race and political party. So over time, they've put that forth as one criteria that can be taken into account. In looking at this particular district, does a certain racialized population tend to vote one way? So much so that it's hard to separate out the political party from the racial identity. And up till now, it has been permissible to take race into account in that way. Now, the people who are suing the state of Louisiana over this are arguing that taking race into account in the drawing of these legislative maps at all, even if it's for purposes of equal numerical representation for black voters, that is unconstitutional and that it goes against what the Voting Rights Act intends. Now, if the Supreme Court were to find in favor of that argument, This is going to weaken Section 2 and by extension weaken the Voting Rights Act as we know it. Section 2 is not about pre-clearance. It's not only subject to certain jurisdictions. Section 2 rules the entire country. In outlawing any kind of discriminatory mechanism, it does not just say in the South or in this state or in that county. This applies nationwide. So this could have an even more dramatic impact in some ways than the Shelby decision, because now any jurisdiction could decide, for example, we can take race into account when we are gerrymandering, that there is no right to equal representation within the legislative districts that we draw up. There is already a great deal of fear going into this election cycle about threats of gerrymandering just along political lines. If race gets added to that, that could quite literally redraw the political map of the United States as we know it. And with that, we could see some very intense efforts to try to dilute the voting power of people of color. Again, not just in a place like Louisiana, but anywhere that politicians deem it necessary.
To follow up, if voters were interested in learning more about the Voting Rights Act and the history of civil rights advocacy for voting rights, what literature would you recommend studying?
I definitely recommend Carol Anderson's book, One Person, No Vote, because...
We read that in class.
Yes. She does a wonderful job of giving some of the historical background, but really bringing it up to the present day and looking at the ongoing impact of the Voting Rights Act, the ongoing discussions and disagreements over how it's being interpreted, and the attacks on it, especially post-Shelby. I think, Anderson's a wonderful historian to begin with and incredibly thorough in her work and her research. And in that book, she sounds the alarm on the decreasing rate at which people of color are being registered to vote compared to just a decade and a half ago. So she is very adept at putting this into proper historical perspective while also looking ahead to what could be the long-term impacts of that. Now, for people who are interested in the VRA itself, much of the literature of the civil rights movement at some point focuses on this. Gary May has done some wonderful work on the legislative history of the Voting Rights Act that would be incredibly valuable for people to read. I also like, just personally, there's a wonderful book called Judgment Days by Nick Kotz, who is looking at the relationship between Lyndon Johnson and Martin Luther King Jr. And he has a wonderful section in there about not just the Selma to Montgomery March, which many people associate, of course, with the fight for voting rights, but the immediate legislative aftermath. What happens when the Johnson administration now has to sit down and write this bill? Then what happens when Johnson has to try to put pressure on Congress to get it through? So I think as a concise legislative history in a much larger book about the relationship between these two men, I think it does a great job of giving you everything you need to know about how that bill actually came to be, both on the activist side of things and the legislative side of the ledger.
Great. Thank you so much. And then for my last question, for listeners who are passionate about voting and voter accessibility, do you have any suggestions for how to get involved? And what would you suggest to help more people exercise their right to vote?
Yeah. One thing I would encourage people to do is to pay much more attention, not just to the Supreme Court and not just to Congress, but what's going on at the state level. Because a lot of the mechanisms that could be used in a discriminatory fashion are not coming out of Washington, D.C. They're coming out of our state capitals. Sometimes they're coming out of our county seats. And it's important to keep an eye on those, sometimes in connection to what Congress or the Supreme Court are considering right now. For example, last time we talked a little bit about the SAVE Act and some of the new requirements it would put in place to have identification that marks you as an American citizen, that confirms your citizenship, and what happens when you don't have that. Well, we've seen examples in recent months of groups of people being stripped of state IDs, looking at the bill against trans folks in Kansas, where unilaterally they had their driver's license taken back, and they were told that to be in compliance with the law, you have to go in and you have to re-register for that license under the gender that was assigned to you at birth. People have already raised questions. What happens if something like that happens a month or two before an election? What happens if we have requirements in place that you need to have an ID, and now certain groups of people don't have an ID? Without rigorous enforcement of, say, Section 2 of the Voting Rights Act, this could have a discriminatory impact, but leave very little time for the Justice Department or other agencies to intercede. So I definitely think that people overlook how some of these issues that we don't think of as even being related to voting rights end up being related to voting rights. Keep an eye on the laws as they're changing and shifting in your own state. Keep an eye on your own voter registration. Now, with some states willingly handing over voting registration information and voter registration rolls to the federal government, there are fears that people are being purged because they are thought to be non-citizens when they may actually be citizens. So here in Ohio, a lot of that is digitized. For folks here in Wood County, you can go to your County Board of Elections online and confirm your registration as long as you have last name and date of birth. So I encourage people, as we get closer to those election cycles this year, keep an eye on your own voter registration. Make sure that you are voting, make sure that you are registered, you're aware where you have to vote, when you can vote, and that you have no surprises when you try to go and cast a ballot. In terms of getting involved, aside from just this on the personal level, there are a couple different ways that people can. I've mentioned organizations last time like the League of Women Voters that have a long and storied history in trying to promote not just voter participation, but voter education. Groups like those, and many of them are nonpartisan groups, those are a wonderful way to see how can I impact this? How can I get other people involved? How can I learn about and teach other people about the issues at hand? I would add that we also, at all levels of elections, we need poll workers. Especially in larger cities or high population areas, we need people who are actually there on election day, helping people get through quickly, making sure that everything is done in compliance with the law. Typically, there are opportunities to apply for this well before the election. I can guarantee you that most municipalities they're not turning people away. They are always looking for folks to be there. And when there are issues that need to be resolved on election day, they typically have a panel of people representing each of the political parties so that you know that, okay, we need to reach a consensus before we move forward on this course of action. So it is incumbent upon more and more people to get directly involved in that, to make sure that it is a fair process, to make sure that polling stations are not understaffed, to make sure that everyone who shows up can get through in a timely manner and no one has to be turned away simply because they can't wait an hour, 2 hours, in some places up to 8 hours just to be able to cast a ballot.
Well, thank you so much for being here today. This was wonderful having you for a second episode. You're so insightful, and I hope that our viewers can take a lot of what you said and think about it and resonate it with it, especially because people think voting doesn't matter, but it does. It matters not just for you, but for your neighbors, especially when everybody votes together. And I hope that we're able to inform more of our voters about the history and the voting rights. So I appreciate it. Thank you so much. Thank you to the Depot social media team and podcast team, Bryn Drebeck, Julia Amlin, and Bryce Torres. And a special thanks to the Falcon Radio and Professor Dr. Robert Alexander, our founder. I've been your host and researcher, Anna McRae. Make sure to join us next time at the Democracy Exchange. Bye for now.
Voting can be a complicated process, but it doesn't have to be. You have several options whether you're a college student or whoever you are. You can vote early at your Board of Elections before the election period. This can vary depending on the Board of Elections, so please look up your Board of Elections hours for early voting. You could also vote by mail or absentee voting. So you have to request an absentee ballot and then you send that into your Board of Elections. Or you can vote in person on election day. If you are a college student, you can register to vote with your permanent at-home address or your student address on campus. Here at BGSU, we have a student polling location in the Student Union on election day.